Welcome to Divorce at Altitude. This is Amy Goscha, and today I have the privilege of having Judge Angela Arkin with me today. A mentor of mine. I've known her for a long time. How are you doing, Judge Arkin?
I'm fine.
Great. Thank you for coming to talk with us today. I know that you were a district court judge for a long time, and now you're doing, private judging, mediation, arbitration. Can you tell us a little bit of about your background? How you came to, become a private judge and mediator and arbitrator?
Well, when I got off the bench, I spent a little time trying to figure out what I wanted to be when I grew up. And I started a small, it was Unbundled Legal Services at a law firm in town. It was kind of a clinic. And the more I was helping self-represented people do unbundled legal services, the more it felt like I was practicing law, which didn't feel very good. And I kept getting asked to do mediations, and I got asked to do a private judge case. And I started realizing that what would be a better fit would be to move to a group where I could do the neutral. So in May of 2017, I went over to JAG and do mediation, arbitration, private judge, special master. Says E&E and E&A, but actually nobody so far has asked me to do it. I was trained to do E&E, E&A, gosh, a few times, and I think the last time was 2012 or 13. And I've never actually done it as the neutral. So I know the process and I know how it's supposed to work, but haven't had a case yet. So.
And then when you were a district court judge, I know that 100% of your docket, how many years was 100% of your docket domestic relations?
That would be July 1st of 2007. So from 2007 to January 1st of 2016, I had 100% domestic, and it was pre and post decree until, I guess, 2014. Middle of 2014, it went to, well, eventually transitioned to solely pre-decree.
Right, and you still have a lot of, you're kind of a family law guru in Colorado. You have a lot of attorneys that, really respect you, judges. So I really look to you.
That's very nice. I still do a lot of training. I guess people aren't tired of me quite yet. I do a lot of judicial training. I have a lot of judges who have me on speed dial, especially about jurisdiction issues. But, domestic relations, this field that we're in, is never boring. And there are often situations where there just aren't answers to the questions that we as judges need to answer. So it's always interesting, always challenging, and it always is helpful, no matter how long you've been doing it, to have someone to bounce ideas off of in a unique situation that you may have run across where there really just isn't any law yet.
Right. Yeah. So, as you've transitioned more into, doing mediation, arbitration, private judging, what would you say the percentage of your practice, over all those areas are? Like, what do you do the most of?
I would say half mediation and half judge/arbitration or med-arb. I'm a decision maker about half the time, and I'm a mediator about half the time.
Yeah, so either, someone going through a divorce, or even as attorneys are looking at helping their clients and the various tools that they have, I think let's start with private judging. Can you tell me, how do you become a private judge?
Well, first of all, you need two crazy people who want you. um, it's very interesting. Private judging, people, and I thought this too, people think that it's only for people with lots and lots of money. I've had some really interesting private judge cases, especially since COVID, where so the parties wanted to get into the court to get their divorce a lot quicker than they could get into court. So they asked for me to be appointed a private judge, and I reviewed their documents and I issued the decree, and they got divorced. Um, One of the parties was self-represented and they couldn't get a hearing date.
Interesting. Yeah.
So,
You normally do think about, okay, let's hire a private judge for people that have money, but that's really good to think about it for different, different scenarios.
yeah, well, that case took me an hour, the total. So it was just 1 hour that got billed. I had another case where they were close to the 10 years on the Social Security. The parties hadn't been married quite 10 years, and they agreed that they wanted to wait to get the decree until after they'd been married 10 years to get the wife that benefit. Well, the district court judge didn't like that idea, that case sitting around on his docket for all that time. So they asked me if I would take it, and I did. And again, it was an hour. That's all it was. But it took 2 years for me to put in the hour, and they got divorced 2 years later. But it's just, I like to call private judge being a beck and call judge, because whatever the parties want is what the judge does. Now, that doesn't necessarily mean that either side can tell you what to do, but it does mean that if the case has certain kinds of needs, they can reach out to you however they want to, and you can address those needs. I have many, many cases that I just do periodic status conferences with, especially post-decree cases, where I'm just sort of managing a complex reunification plan or a complex high conflict family. And we just have periodic status conferences to manage it. There are other cases where I had a case where there was an emergency motion to restrict, and I've been having, again, periodic conferences with them to release the restrictions, and there have been some setbacks and those kinds of things, but pretty much that case has been managed by a series of status conferences. Then there are other cases. I had a case this past year during COVID where they needed 4 days, and they bifurcated it. They did 2 days on the APR issues and then 2 days on the financial issues, and that one they couldn't settle at all. There are a lot of my private judge cases that settle, which is wonderful. And, I'm the one dancing a jig down the hall because I love it when cases settle, whether that it's private judge or not private judge. It's always better for the family. So I do sort of the same process, and I'm sure most judges are the same as a private judge as they were as a regular judge. When you're a regular judge, you basically have a big pile of cases and you set the process and the parties are stuck with whatever.
Right.
If you're a private judge, the parties tell you what the process should be. And so long as it's within the framework of a district court judge's role, you can accommodate it. Um, I will tell you, I think in some ways being a private judge can be really much more cost effective because you never have to prepare for trial more than once.
Right. And
This,
talk to me about,
go ahead.
yes, just for our listeners that don't understand that, what can happen if you're in just the normal, I guess, courtroom, as far as preparing for trial and then not being able to go to trial? What happens sometimes on a regular docket versus in a private judge docket?
Well, on a regular docket, the judge gets to decide generally how much time you're going to get to try your case. There are districts in Colorado with that, even though it's a complex case, they don't have time, so they're going to give you a half a day.
Right.
And there are other districts where you might get 1 or 2 days or even 3 days, but they will either give it to you a year from now, or they'll give it to you a day here and a day there and a third day at another time. And by then, of course, the judge has had 50 or 100 more cases and has completely forgotten all the facts of yours. And then it takes another, month or two to get a decision out of the judge. And he or she may have, just by being human, have mixed up all the facts at that time.
Yeah.
So it can be very challenging. A private judge, as I said, you can use it for just these very limited circumstances and these very unique situations. But most often it's people with complex DR issues, APR issues, complex, complex custody issues and or complex financial issues. And the district courts just aren't going to have the time to give you to address those in a fashion that would allow the court to really look at your client's position carefully. If you're a private judge, the parties agree to appoint you. They agree on the length of time of your appointment, and they agree on how you are no longer the judge in the case. And that order of appointment that's signed by the Chief Justice of Colorado Supreme Court, that is jurisdictional. What that means is when the Chief Judge order of appointment, if they say, we're going to appoint you for a year, when that year runs out, the private judge can't act anymore. They're out of time. So they are no longer allowed to be the judge on that case.
Are you allowed to, or can you extend that? I mean, I haven't done enough private judging cases. Actually, strike that.
The only way to extend it is to do a new motion.
Yeah.
I've had a number of cases extended because the parties needed more time and didn't have their act together. So you just have to do a new motion and ask the Chief Justice to appoint the private judge again. I actually have a case where I did the pre-decree and the dissolution of marriage, and now they want me back on the case post-decree, so I'm being reappointed for the post-decree issues.
Yeah, I was wondering that you probably get that a lot where it's like pre-decree and then they want, if they have post-decree issues, to have you appointed again to deal with those issues.
It depends on how much they hate me. I'm joking, but really, that's kind of true. If one side or the other really, really dislikes the decision that you've made, they obviously aren't going to want you back on the case. But sometimes they're crazy enough to want me back, and so I'm happy to do that.
I was going to say, I would not see a situation where they wouldn't want you back. I mean, you're an amazing judge. But that's my opinion. Yeah.
Yeah. It's not about pleasing people.
Yeah.
It is, however, about trying to get them to solve their problems.
Yeah, and you and I talk not just in this episode, but in previously working together when I was your law clerk, or just on cases. Problem solving for families is key and is very important. Are some of the tools that you use in private judging, to help people, I guess, move along towards resolution? Are your status conferences? Can you talk to me about that? How does that help kind of keep a case on track, in your opinion?
Well, so if you're a private judge, you can't have any sort of privacy with either side. You can talk to the lawyer separately, just like you could in chambers as a judge, but you can't talk to one side or the other side without everybody being present.
Right.
You can have status conferences without a court reporter because simplified dissolution allows that. But basically, even though you can be flexible with the process, you can't really do anything that would be improper for a regular sitting district court judge to do.
Right.
Also, I mean, the reason that people want a private judge usually is because they want the opportunity to appeal your decisions if they want that option. So it is like being a regular sitting district court judge, except you're just appointed for that one matter at that time. So I think it's very effective for certain kinds of roles, for certain kinds of cases, and it works for a lot of people. During COVID, I got a lot of private judge cases because people couldn't get hearings.
Yeah.
I also got a lot of cases from the courts out there that were extra burdened. Some of the very, very busy districts where people were looking at a year or two, sometimes even longer, to get the kind of hearing that they wanted. Or they weren't even offered the opportunity to have a full day or a day and a half or 2 days, whatever. So,
Yeah. The other thing that I remember as a law clerk that I really thought was helpful for litigants in your courtroom is after you had reviewed, the at least the JTM, the Joint Trial Management Certificate, you would talk to the parties in counsel and you would say, I haven't heard all the evidence, but here's kind of where I'm at with the case. Do you do that with, as a private judge as well?
yes, lawyers ask me to do that
Yeah.
routinely.
And do you think that that helps with kind of driving why you're seeing parties settle, when you're able to kind of talk to them at the beginning before the hearing starts?
Absolutely. Uh, there are some folks who just aren't going to settle, and that's okay. And also, I will tell you that sometimes the way I see it beforehand is very different than the way I rule. Uh, so, there's just, you can't be clairvoyant, but the challenge is it's very expensive to go through the process. I do rule from the bench most of the time, and these days, what I'm doing, since it's so cost effective for people, I'm having the court reporter send me a rough transcript. And then I review the transcript. I add whatever citations or additional language I want to, or strike whatever language I didn't intend. And then I just issue it. And usually I attach it to a form of decree and issue it very quickly. Usually I can get those out within 24 to 48 hours. So it's faster. People know what the ruling's going to be,
Right.
and it's just much more cost effective for them.
Yeah. No, that's great.
But different judges do it differently. And, if you want a written decision that's, these beautiful, um, well ordered, specific decisions, there are a lot of judges who will do that. And, you know, it's kind of like I said, it's up to the parties what
Yeah,
they want.
and it's just more flexible and tailored towards what they need,
Yep.
which is great. Anything else that you would, I guess, before we kind of switch gears to mediation, or some of these other areas with private judging, in general, I'm curious about the status conferences, and you had mentioned that that's a really effective tool in certain types of cases. Would you say that that's really helpful in cases where children are involved, or is that kind of a too
Any
overarching?
kind of case.
Yeah,
Any kind of case. The private judge cases that are financial, you're just regularly checking in with the parties regarding what the status of reports are, issues regarding rebuttal reports, issues regarding the appearance of witnesses, who's paying for what, those kinds of things. So regular status conferences regarding financial issues are also very helpful. Um, I would say, depending on who you hire as your private judge, they're going to have a particular style. I always have a status conference with people, sort of status conference with people before I take the case
I
to
see.
talk to them about the flexibility of the process, what they're looking for, how they want to do it. So, a lot of that is going to be when you're choosing a private judge, you want to make sure that what you intend is kind of what they have in mind as well. But the people who I know who do the private judge work are generally going to be as hands-on as the parties want them to be.
Right. Yeah, that makes sense. So let's kind of switch gears towards, mediation. I know you do a lot of mediation. I've used you as a mediator. What is your process with mediation? Do you talk to attorneys prior to the actual mediation, or what do you find most effective in domestic relations cases as the
Well,
mediator?
sometimes it kind of depends on the case. There are certain cases where I almost never get anything except very complicated cases. I get a lot of complicated APR issues. I get some complicated financial issues as well, but uh, the APR issues, sometimes what a party is looking for doesn't really jive easily with the information that the party sends to me that they want me to look at beforehand. Usually both sides send me an hour or two, sometimes even more, to read. Um, they always send me PREs, and they send me sworn financial statements, spreadsheets, blah, 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 blah. It's, for me, it's really important for me to be prepared for the mediation. But if they send me a position statement that makes it clear that the position that someone's taking is going to be challenging, sometimes I will pick up the phone and call the lawyer beforehand and say, have you talked to your client about this? Have you looked at this issue? Maybe you should research this or that, those kinds of things. Um, Kind of an example would be if a party is looking at buying a house and they haven't looked at whether or not they're going to qualify for a loan and
Right.
what they would need as the equity and what they would need as the income for maintenance or child support or both. And so those kinds of things, if you can contact them beforehand and say, hey, maybe your client should look into this before we do the mediation, that would probably help us get that issue resolved. Or um, some kind of an issue regarding choice of school, and one person is objecting to a school, but they haven't really looked into the school, they haven't visited, they haven't talked to anyone, blah, blah, blah. Sometimes it's worthwhile to call them and say, maybe this person should go on the website and look into it, and have they considered this, and blah, blah, blah. So there are often issues where it's clear that it would be helpful to the parties to make the most of their time at mediation. And sometimes you can do that just when you're walking from room to room, virtually or in person. But other times, having that information beforehand can just really make a huge difference in settlement.
Right, because the parties, it's in their power to make an agreement, and if they don't have the information there that's key to be able to do that, then mediation isn't productive. So it sounds like you
Right.
spend a lot of time reviewing it to figure out what else do we need, and helping and assisting counsel, to make sure that they're prepared, and their clients are, to resolve the issues.
Yeah. Um, Sometimes I review it all night long. I don't charge people for that. But some of the cases are complicated enough that, I'll wake up at 4 a.m. thinking about, how to solve this problem or how to address that. There are cases, of course, where people are pretty stuck and their positions are just not terribly reasonable. And sometimes even giving them the perspective of what that crazy judge might do to them still is not enough for them to be able to move forward. And, that is what it is. Usually one or both parties have to find a compromise that they can live with.
Right.
And the amount of certainty, that's so helpful to people, and it's so much cheaper than going to court and rolling the dice. But
Yeah. What are some of the techniques, Judge Arkin, that you use in mediation if someone on one side just has a really unreasonable, position? Like, what are some of the techniques that you use to kind of help get that person unstuck?
well, it is important, of course, to listen to what people have to say and to really understand sort of why they are in the place that they're in. Um, Sometimes their perspective on the other party is so firm and certain, and you're really just not going to get that person to see the other person a different way. But it can sometimes be helpful to them to understand how much power the court has and how the court might see the world so differently
Right.
from them, that if they take the risk and they spend the money and they take the time and they pay for something, they could end up with a result that they feel like they might not be able to live with.
Yeah, that makes sense.
Um, sometimes their lawyer is the best person to sort of give them that message. Many of the lawyers I work with have already given their clients the message I give them before I talk to them.
Right.
Every once in a while, there's a lawyer who will say, I think this legal issue goes in my client's favor, and the lawyer and I won't necessarily agree on how to see it. And
Yeah.
that's probably pretty normal. That was true in the courtroom too. And that's fine. I do like to give people a sense of how much it's going to cost them to be right.
Yeah, yeah, exactly. And I do find sometimes, even if I've talked to my client about, a position and they don't like it, sometimes it's better for them to hear it from someone who's been a judge and who would be making a decision. So do you find that finally sometimes a client will listen once
Oh,
you're
yeah.
in the room?
Yeah, that's mostly, in the tough cases, that's mostly why lawyers want me to be the mediator, is to give their client the bad news because when they hear the bad news from me and I'm not wearing a robe, they can walk away from it and find another solution. If I'm sitting in a courtroom with a robe on, they're stuck with the bad news. I mean, they can appeal, but that's another $10, $20, $30,000.
Yeah.
And, 1 in 3 cases that are appealed gets overturned on some issue, but it might not be the issue you want. And then you have the privilege of getting to try it all over again.
Right.
Sometimes in front of that very same judge that you hate.
Yeah. Plus all the time that's gone by, plus the money. So that doesn't a lot of times resolve the issue. One thing I'd like to really focus on is I know that you also do med-arb. Can you talk to me about what med-arb is and, what types of cases usually will you use that in, or will attorneys request that in? Just wanted to get your
Med-arb can be, it's probably, I would say it's probably my favorite process, although it's not
interesting.
linear.
Know that.
Well, it's really always wonderful when you can get people to resolve the problem on their own, and med-arb gives the parties the opportunity to do that. When you have a really complicated case with lots and lots of very specific issues, and it's either APR or financial or both even. Sometimes med-arb can be very effective because the parties can mediate lots and lots and lots of things that you don't have to deal with in arbitration. And then the arbitration can just be those places where they're stuck. And I think probably the most wonderful thing about med-arb is that the process can be as formal or as informal as people want it to be. When I do med-arb, the first thing I always do is have a phone conference with the parties once they've hired me to do med-arb, and we talk specifically about what their expectations are in terms of a process. But that can even change over time. So I have had a case where, we had a full day of mediation into the evening, didn't settle.
Right.
Then we went to a full day of arbitration, formal arbitration, with, everything was formal except me not being in a row. But I was up front ruling on objections. They called witnesses, openings, closings, ruling from the bench, the whole shebang. So that was med-arb. And you go from that all the way to the parties mediate with me in the morning. The kiddo had to start school the next day. The parties couldn't agree to where he was going to go to school. Each lawyer handed me a list of names of witnesses to call. I spent the entire afternoon calling people up and interviewing them. That evening, I emailed the parties where the kiddo was going to school tomorrow, and then I wrote up a decision.
Wow, that's really cool.
It was.
Yeah, to be able to have help.
Yeah. Yeah. But it's kind of everything in between. There are cases where it's a parenting plan and, pre or post decree. There's like 90% of the things they can agree on, but then they're just those little issues and they're just stuck. And most often, what I see is lawyers just sending me the paper. They say, you were in mediation with us, you've heard my client, what, blah, blah, blah. The only part of that that's really a little unique is that after the mediation, the parties have to share the information. So mediation, of course, is confidential.
Right.
Everything that you hear on either side is confidential. And if people don't reach an agreement, as the person in the middle, you aren't allowed to share information. Arbitration, the parties have to share whatever information they are wanting you to decide about.
Right.
So at that point, they have to actually exchange information. And a lot of the time at the mediation, they're going to have done that, sworn financial statements, those kinds of things. But there are things that they may not have shared in mediation that in order to get the decision they want, they have to provide the other side with the information.
Right.
I have had people who will do, like morning is mediation, afternoon is arbitration. But most often it just seems like they get to the arbitration place and they just kind of throw the paper at me and say, make a decision. Not sure why that is, but it does seem to work well for the parties to do it that way.
Yeah, I can see why that, you would like that tool. I mean, and I've kind of used it, just not called it med-arb, even in cases that I've had in front of you, that technically, I guess, would be a form of med-arb, sending you the proposed, final disputes that they weren't able to resolve and you ruling on those through arbitration.
Right. So some people start in mediation and they get close, but they're not quite there. And then they agree to arbitrate the issues that they couldn't agree to in mediation. So it's med-arb, but it didn't start out that way.
Right. Oh, yeah. Yeah, that is interesting.
Yeah. And it is kind of unique because if I know a case is going to be a med-arb, I might not address the parties regarding the issues in exactly the same way because I really want them to make a decision that resolves things, and I may entirely disagree with their position, but if it's in med-arb, I'm not going to be telling them that,
Right.
Yeah,
How many
so
times do you see that happens where it's like people will end up making an agreement that's very different than if you were to,
oh, all the time,
yeah.
all the time, which is much better. Always. Not my life, not my kids,
Yeah.
you know? Uh, this role of neutral, of judge, whether it's private or public, the best way to do it is to judge as little as possible. And if you can't pull yourself out from the disputes between the parties, then you're not doing it right.
Mm-hmm.
Not about you. It's, these people created a life to the extent you can figure out what it was they created because their perceptions of it are so different.
I bet that's so interesting when you go between rooms and just seeing the different perceptions.
Oh my goodness. Oh my goodness. Sometimes, it's just completely dark in one room and completely light in the other. And you're just wondering, were these people ever married to each other? It's pretty amazing.
Yeah.
And frankly, that's actually the cases I get most often. I don't get simple mediations. Why should people spend the money to bring me something easy? I do volunteer mediations in Douglas County when I want something easy.
You have time for that. Wow.
But I do, yeah, I have a day a month. I've been doing that since I left. I just feel like people should do pro bono. So
Yeah, no, that's great. I didn't know that. That's really, really cool. I think the last part area I wanted to focus on, Judge Arkin, today with you is special master. I know that, when I was your law clerk, a lot of times you would have a special master appointed if there is a specific issue, like the validity of a prenup, or I don't know. Can you talk to me about special master, and when is that a useful tool in domestic relations? And I guess first start out with, what is a special master?
Well, I know that you're so amazing. You did the research and you had the statute there from the Uniform, I guess the Mediation Act, but
Yeah.
the almost everyone's special master appointments are Rule 53 and CRCP 53. Basically, what you are saying as the court is there's a complex issue that I'm not going to be able to resolve in a timely manner that needs help. These people are stuck. They're stuck in the discovery process because somebody's not playing fair, or at least there's an allegation that somebody's not playing fair. There's a complex business situation and the business needs to be valued. And so, it's going to take days of trial to get the business valued, and the court just doesn't have time. Common law marriage, oh boy, that's just a day or two of hearing because
Right.
all those fact witnesses, et cetera. So that's a really good thing to send to a special master. Those are the kinds of things. And of course, marital agreements. Is the marital agreement valid or invalid? And it may just be a legal question, but it's a full day hearing usually to figure that out. So, and many judges, often the case can't really move forward or get resolved
Right.
if those issues don't get resolved.
Yeah.
So, so taking a slice of a complex case and giving it to usually a former judge is most of the people who do special master, but often if it's not a former judge, it's most often going to be a lawyer who has years of expertise in a particular area.
Right.
But you really just want somebody to resolve the issues as the judge so that you can move forward. Now, as a practical matter, the special master's findings of fact are, they're not binding on the court, but usually the court's not going to rehear those issues.
Right.
The law is usually, that the court can decide that the special master didn't apply the law. That's a de novo review. The court can review the entire thing de novo, but generally they're going to be appointing somebody who they are going to believe is going to do a thorough enough process that they're not going to take the time to undo what this person did. It's very expensive to do that. And a judge doesn't have time. What's the point? So as a practical matter, when you appoint a special master as the court, you are kicking that issue to someone neutral to resolve it for you.
Right.
And when they send it back to you, hopefully it's done and you don't have to deal with it anymore.
Yeah, one question I have just out of curiosity is, as a private judge, do you appoint special masters? I mean, I know you used to do that even when you were on the bench, but does that happen even when you're a private judge, or do you just serve as the special master?
I actually have a case where I appointed a special master as a private judge. Very, very complicated case, but it was APR issues that there were so many professionals in the case, it needed to be managed by someone who was used to managing mental health professionals. So I suggested to the parties that they find someone who did CFI work, and we appointed her as a special master rather than a CFI because her role wasn't to investigate, but it was to gather information. Prior to the appointment of the special master, a therapist who was involved in the family system was doing the reporting to the court and to the parties. Well, that was not helpful because the therapist was having to provide therapy. And when the therapist was presenting reports to the court, the parties, as they became more and more divided, got angry and upset with what the therapist said was going on in the case. So the therapist couldn't be effective as a therapist anymore because the parties felt that she had taken sides.
Yeah.
So, and there was family therapist, a reunification therapist, individual therapist for the children, individual therapist for the parents. There were just a ton of people. And there was also a PRE. And so managing the case through all of that process, it just felt more helpful to have a special master do that.
Yeah.
Uh,
Yeah, that's really creative. And I mean, that's interesting. I mean, that answers my question too about children related issues and hiring a special or appointing a special master.
oh gosh, my favorite special master appointment ever. I appointed someone who did PRE work, who agreed to be a special master in a case where a 4-year-old clearly had been sexually assaulted by somebody or treated inappropriately by somebody. And mom claimed it was dad, and dad claimed it wasn't him. And DHS had investigated, and a CFI investigated, and neither one of them thought it was dad. But we just couldn't move the case forward because mom was certain it was dad. So I appointed the person as a special master. She was a PhD psychologist to do parent-child interactionals. And she did 2 with each of the parties with the child and did a report that she shared with the parties, and the case settled.
Wow.
Yeah. Yeah. And dad had, and in addition, it settled like within 2 months.
Nice.
Yeah.
Yeah.
Well, I spent years watching cases and situations where a parent was restricted from access to their child for months and months and months. And with young children, that is so dangerous and harmful. If the parent isn't dangerous and harmful,
Great.
the process itself is so much more harmful to the parties
Yeah.
than, vindicating a parent. But it takes time. And so we were just trying to figure out a way that this father could keep from being kept from his child for some significant period of time. And, it was the only way I could think of that could happen.
Yeah. Wow. What a good result, like a creative
Oh,
way.
it's wonderful. It was so cool. I was thrilled because, it was just a complicated situation. I think what's so important for parties and lawyers in the domestic relations space is to think outside the box sometimes for problem solving, because the court process is never the best way to
Yeah.
problem solve in domestic.
Yeah. It just isn't, just.
No, I mean, you're one of the most innovative lawyers I know, finding ways to resolve issues in a way that everybody feels heard and considered, but also isn't going to break the bank. I mean, that's so huge.
Yeah, that's why I wanted to talk to you about these various issues, because I do think besides clients understanding what are the options, also lawyers really understanding like what they can do to help their clients,
Yeah.
you know, and what framework is really going to help, whether it be hiring you as a private judge, med-arb, whether or not a special master is needed, just
Yeah.
the unique ways that you have used, like a special master even to solve problems.
Special master is probably my least favorite role, and that's mostly because people don't want you. I mean, the judge does. The judge wants you, but usually one side or both doesn't want you. And the only reason that special masters are appointed in cases, well, not the only reason, but the primary reason is because the judge can do it sua sponte, which means of his or her own accord. He or she can do it without the party's consent. He or she has to discuss it with the parties and get their feedback and input. But if the judge believes a special master is necessary, he or she can appoint one, and then the parties have to pay them.
Yeah, that makes sense.
Yeah.
Yeah. Well, I think just to kind of wrap everything up, Judge Arkin, is there, I guess, anything else that you think would be important for, attorneys or clients to know when they're embarking on, deciding on a private judge, anything regarding that?
Just keep in mind that for a private judge, you have to be thoughtful about the order of appointment. You should reach out to whoever's going to be the private judge and ask them for samples so that you don't have to reinvent the wheel, but also so that you can pay attention to the detail of how long is this person going to be a private judge? Are they done with the case when 60A or 60B is done, or is it motion to reconsider? Is it post decree only? How's that going to work? With arbitration, you have to be very specific about what the issues are that are going to be arbitrated.
Right.
An arbitrator can only really be overturned if either they have a stake in the case or if they have gone outside the parameters of arbitration. That's true with respect to financial issues, not so true with respect to APR issues, but a court is almost never going to do a review of what an arbitrator decided for allocation of parental responsibility if the arbitrator has a good record and made good findings. A judge is never going to turn it over. It's just they're supposed to review it and decide whether to overturn it or not. But as a practical matter, they're almost never going to do that.
Right.
So you want to be very thoughtful and careful regarding the instruments you use to have a decision maker, a private decision maker, come into the case.
Yeah.
So really, that would be my suggestion. Whether it's med-arb or arbitration or private judge, it's very important that the tool that you use to get the neutral involved is what you anticipate it will be.
Yeah. Well, thank you, Judge Arkin, so much for your time today and sharing all of your thoughts and knowledge. What is the best way if people want to get, in touch with you? What's the best way for them to contact you?
I'm on the JAG website. My email, arkin@jaginc.com, and shoot me an email. You can call me at the office. It automatically comes through to my cell phone right now, but it also automatically generates a message that I get in my email. So if you need me, just reach out in either of those ways.
Great. Thank you. I really appreciate
Thank you.
it. Thank you.